Before I introduce Jack formally, I wanted to introduce myself. I'm Renee Reisman. I am the Educational Programs Coordinator for CLA Los Angeles. And I wanted to play a message by our Executive Director, Alma Robinson, that explains not just our educational program services, but our other services as well. So I'm going about to play this little video and you can learn more about CLA.
Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
Those were our great services. So with all of that out of the way, Jack Lerner is a professor at UC Irvine, and thank you so much for joining us tonight. You're going to tell us about likeness rights, which is the more official way to say how to make content about real people. And we're really excited to have you.
Thank you very much for having me. I have a number of slides I want to share with folks. First, I just want to talk a little bit about this issue. This is becoming more of an issue, making content about real people as streaming has taken off over the last 2 years. And of course, it took off before that. And the the so-called golden age of documentary took off as well prior to the pandemic. But since then, we've seen so many compelling docudramas, biopics, as well as documentaries. And so this is an area that, we're coming across in our practice really very commonly. And so it's my pleasure to be here to talk with you about all these issues. Okay, first thing I want to do is just make sure everybody understands I'm not here to give you specific legal advice. I'm here to give you an overview of what some of the issues are, what goes on behind the scenes when lawyers are advising clients on making content about real people. And so keep in mind, this is not legal advice. If you do want legal advice, you either have to retain the clinic that I run or be willing for me to send you a bill. So that's important as well. Okay, so I want to tell you a little bit about myself. I'm a professor at UC Irvine School of Law. That's the beautiful building surrounded by palm trees that you see on the left. I've been practicing law with filmmakers for almost 2 decades, and I've been the director of the UCI Intellectual Property Arts and Technology Clinic for the last 7 years. And before that, I was at USC for a little bit more than 7 years. Before that, I was at USC doing something similar for 7 years. And I've done a lot of work on fair use. I'm going to talk about fair use for a few minutes, but mostly we're going to be talking about right of publicity, life story rights, and how it all works. But for filmmakers or writers, journalists, artists, you can go to this website, ipat.law.uci.edu, and then you can click on, there's a link for filmmaker services, and you can see some of the films that we've worked on, and there's also an intake page where you can fill out an application seeking to retain us. And the clinic is essentially a pro bono law firm that operates out of the law school. All law schools have them. Ours focuses on working with creators, filmmakers, journalists, artists, academics, sometimes scientists or technologists. We also work with startups, and we do work in a really wide range of areas, everything from releasing a legal guide for attorneys dealing with the use of rap lyrics in criminal trials, to getting the law changed on child welfare transparency, to advising many, many filmmakers, particularly on fair use. And we've had our films screen at major film festivals, including Sundance, Newport Beach Film Festival. So all of you, you can look me up on UCI's website. You can, and my profile is also linked to on our clinic's website. And please feel free to email me. And if I can't help you, I know lots of affordable lawyers who can. Of course, one of the things we do is refer people to California Lawyers for the Arts. All right, I'm going to give you a very, very quick roadmap of what we're hoping to do today. A big chunk of what I'm going to present, and I hope to leave a lot of time for Q&A, and I know we've gotten some in advance as well, so it's always a treat to see what people are thinking about. There is no such thing in the law as life story or likeness. That is a term of art. Likeness is included in right of publicity, but that's really more about identity. In the law, the relevant legal regime that we talk about is right of publicity. Again, we're going to talk about copyright a little bit. We're going to talk about how to make sure you're not committing defamation, also known as libel or slander. Libel is written, slander is spoken. And then we'll talk a little bit about privacy rights that you have to think about as a filmmaker, an author, or someone else who's making content about real people. Then we're going to get into the practical stuff. Why get a release? What's at issue there? How to do the review, how lawyers do the review, and what we ask our clients for. We'll get into the anatomy of life story agreements, and then we'll get into Q&A. We'll talk about E&O insurance, errors and omissions insurance, and so on. So let's get into it. First, I want to talk about what the right of publicity is. Okay, essentially, it's the use of someone's name or likeness without consent, resulting in injury and to commercial advantage. It was once restricted to advertising uses, and various statutes and doctrines do that to this day. And they don't cover, for example, just making a film about someone or telling someone's story. One key thing to know, and we're going to talk a lot about this, is there's a lot you can do, a ton you can do without getting permission. The problem with that is that it's practically more difficult, and sometimes you can get into trouble, and you can just really lower your risk by getting permission. And so very, very often people do that. And we'll get into why that is. So I mentioned once upon a time, right of publicity was just advertising, and that's not the case now. Now it is more broad than that. So it's not just for what the First Amendment definition of advertising is, which is to propose a commercial transaction. It's now using their name to commercial advantage, like putting their name in a music video, or putting someone's image in a music video just because they know that the music video will be more appealing and more people will like it. And the classic example is, it's not an advertisement, but when an artist down in Santa Monica put the Three Stooges likeness on a t-shirt and sold the t-shirts, the court said this violates the right of publicity. So let's break down how the right of publicity works a little bit better. I'm going to talk about California and New York. Now, one of the things to understand about right of publicity is it is not something that is uniform across the country like copyright law, right? So 99.9% of copyright law is straight up federal. Right of publicity, every state has their own right of publicity law, right? So we had someone who was doing a film in Mississippi about a really interesting person in Mississippi. It was a really interesting film. And ultimately, we looked at it and we said, you know what, we can't advise you on Mississippi law. We're not Mississippi lawyers. A lot of lawyers will do it anyway, but if you look at the rules on unauthorized practice of law, it's not necessarily a good idea unless it's like a 50-state survey. But anyway, what we can do there is partner with attorneys there or something like that. Long story short, in California, there's a statute passed by the legislature which covers advertising, but then there's a common law doctrine developed by the courts over the course of many decades that's more about using someone's name or likeness to commercial advantage, even if it's not an advertising use, so more of a merchandising use or something like that. The New York statutory right is more restricted, and there are numerous exceptions. I should go back to that. One is newsworthiness, right? So when you're talking about something in a news context, you say, oh, so-and-so did this, or, the person who was rescued from the burning building is named so-and-so, or the person who did the rescuing is named so-and-so, that would be a really good example of a newsworthy exception, even if you're using it for commercial advantage. Another one would be parody, criticism, or commentary, what the court also calls transformativeness, right? So is there a real artistic use? Are you using more than, are you just straight up using the artist's likeness and nothing else, or the plaintiff's likeness or something else? So New York statutory right is a little bit narrower than the California statutory right. So until this year, until December 2020, when Governor Cuomo, at the end of December 2020, when Governor Cuomo signed a new bill, New York did not have a right of publicity for deceased individuals. Starting in 2020, they do have that. And so, it's limited to people who were domiciled in New York at the time of their death. And so that was actually an issue with Marilyn Monroe. If she was domiciled in New York, then until a year ago, then there would be no right of publicity. And so you could sell Marilyn Monroe shot glasses and stickers and whatever else, and her estate wouldn't be able to do anything about it. Whereas in California, if she was domiciled in California, then her estate could bring an action under the California statutory right for deceased individuals. Okay, so that's basically, but now we have California right of publicity. So you see the California statutory right is actually narrower, right? It's about advertising or selling, soliciting purchases of products, merchandise, goods, or whatever. Whereas the common law right is broader, using the plaintiff's identity for your advantage, commercially or otherwise, lack of consent, and injury. So there are some exceptions written into the law. One is incidental use, so it's not essential to the purpose of the publication. Another one is newsworthiness in connection with news, public affairs, sports broadcast, or account, or any political campaign. That's a blanket exception. And then you have transformative use. Were the raw materials used, or is the depiction of celebrity the very sum and substance of the work in question, right? So the classic example there is the Three Stooges case, which is called Comedy 3 Productions. And again, this was put on a t-shirt and being sold by a t-shirt vendor, and Three Stooges estates, got involved, and they said, you can't do that. And the court said, this is the thing, is the celebrity likeness but one of the raw materials from which an original work is synthesized? Does the value of the work come from the skill and reputation of the artist rather than the fame of the celebrity depicted? Then it's okay. If it is just straight up trading on the appeal of the celebrity, you're going to be in trouble, right? So putting somebody's likeness on a shot glass, putting somebody's likeness on a billboard to sell something, not okay. And I'll give you a couple of examples where this comes up. So one example is at some point during either during Obama's first campaign or his presidency, he was photographed wearing a certain kind of windbreaker. And the windbreaker company put a picture of him with their windbreaker on a billboard. And so Obama's people called them and said, hey, you can't do that. And that's a great example. And this is where it gets tricky. Let's say you have a big celebrity like Kim Kardashian, and she decides to wear, some company's jewelry. Let's say she wears Gucci. She has a Gucci bag. And so Gucci says, oh my gosh, like she was out wearing our bag. We should put that on our blog and maybe put it in an ad campaign. This is so cool. You can't do that, right? And so sometimes when people give Kim Kardashian the Gucci bag or whatever, it's not because they want to use that in their advertising. They want all the paparazzi and the People magazine and the Inquirer and all that to photograph her wearing their stuff, because that will get them buzz and that will get them commercial advantage, not because they're gonna actually take that image and use it themselves. And so, a number of lawyers I've talked to, and we would do this too, we generally deal with folks that would be doing that, but a number of folks I've talked to have said to their blue chip business clients, if somebody wears your stuff, you can't be putting that up on your site, your material. So that's a good example there. Now we get into transformativeness. These two brothers were the basis, with their permission, for two of the avatars of the Matrix. In the Matrix, and if you remember, there were these two actors who are albino, and they were these two actors. And then somebody made a comic book about them. And there the court said, no, yes, it's about to, it's kind of inspired by these people, but this is not just only dealing with, this portrayal is not the very sum and substance of the work in question. It's not, it's more the defendant's own expression, and they're not just simply trading off of the fame and appeal of that celebrity. So there the court said this is transformative use, and these folks don't have a claim. In 2018, we had a really, really good case that really kind of reaffirmed what the law already said, but the trial court had messed up so bad that the Court of Appeal had to really come down pretty firmly here. And so what happened was there was this neat little series called Feud, Betty and Joan, which is from 2017 on FX. And the creator said, we want a lot of verisimilitude, if I said that correctly. We want a lot of fealty to how things actually happened and the way that these people actually acted. And Olivia de Havilland was portrayed in the film, and she was portrayed by Catherine Zeta-Jones. Now, Catherine Zeta-Jones in the film, the portrayal of Olivia de Havilland called the Joan Crawford character the B word, B-I-T-C-H, and Olivia de Havilland was very offended by this, even though she was in her 90s and lives in Paris. Her people were paying attention. They were not happy about it. They said she never used that word. She's way too refined. She's way too classy. She called her Dragon Lady. Now, if you ask me from an artistic standpoint, that would have actually been better for the movie. If you want to be faithful to what happened, then and what actually took place, that would have been better. But the filmmakers made another decision, and they said, no, we're going to say the B word instead of Dragon Lady, and that's how we're going to do it. So the de Havilland estate brought a suit for violation of her right of publicity. FX Networks responded with what's called an anti-slap motion. Now, if we were in a classroom or an auditorium, I would ask for a show of hands, who knows what a slap motion is? I'm going to assume some of you do and some of you don't. Anti-slap motion. So anti-SLAP stands for anti-strategic litigation against public participation. The idea is when someone brings a lawsuit because they don't like what you're saying and they want to shut you up, they bring a lawsuit essentially to deny your ability to participate in public debates or whatever. And so the California legislature has given special mechanisms by which to get a very quick resolution and attorney's fees and a very quick appeal if you lose in order to battle these kinds of motions. So the trial court in LA denied the motion of FX Networks and said, this is not a strategic lawsuit against public participation. This was not transformative because it was more realistic. It was the more realistic, the less transformative it is. And of course, all the lawyers and anyone who's read the dozen cases that have come out over the last 50 years were like, what are you talking about? That you're getting it completely wrong. It's not how close to reality is. It's how much creativity is involved and how you tell the story. And this would have rendered every documentary and every biopic and every docudrama illegal unless or subject to civil liability unless you go to the individual and get permission, which of course sometimes individuals just say no. Other times they would say, well, that it's going to cost twice as much for your production or whatever it was. Here, de Havilland said that this, I would have expected to get $1.38 to $1.5 million for the use of my likeness, and she was a minor character in the show. So the Court of Appeal said, no, that's not how this works. That's not how any of this works.
That's not how it works. That's not how any of this works.
And docudramas and documentaries, if they don't have a newsworthiness exception, then they have a transformativeness exception. And so the court reversed the trial court on the anti-SLAP motion and sent it back. And so this was a big victory. This is a really strong case. And since then, we've seen a number of cases brought around portrayals. So one of the characters in Tiger King, I think it's the woman on the left, brought a claim. The prosecutor in When They See Us brought a claim, and I can't remember who the plaintiffs were in these other two cases, but they all lost. And these cases cited de Havilland. And so we've actually seen several cases that cited de Havilland. In addition to these, so one is Mossack Fonseca, the law firm from Panama that was exposed in in a Netflix film, the court said, you can't control this celebrity's image by censoring disagreeable portrayals. Brown versus Showtime Networks was, I think, the one about I forget which one that was. And then there's another one called Jackson versus Netflix. And so these are pretty strong endorsements of this idea that, if there's some creativity, if it's a run-of-the-mill docudrama, if it's a run-of-the-mill documentary biopic, then you're pretty much going to be able to make your film. You're pretty much going to be able to make your film, even if you didn't get permission. And then you might be asking, okay, well, why do I need to get permission then? Like, what's the point? We will get to that because there are very good reasons why you might want to, but we'll get to that. Another case that came out earlier this year is called Porco versus Lifetime Entertainment Services. And this is about the Romeo killer, the Chris Porco story. And I forget what it was on the Lifetime network. I just want to be clear. This is not Porco Rosso, the wonderful early 90s film by Studio Ghibli, Hayao Miyazaki. It's about the Chris Porco story with the Romeo killer. And there it said it was based on a true story, is a broadly accurate depiction of the crime. And the court said this can be allowed to go forward. And this was not an endorsement or recommendation. Promotional materials were ancillary to the protected use, right? So they're not the protected use being the actual story. So here's another example where people are saying, you can't trade on my likeness by doing a docudrama that involves me. And courts are saying, no, that is allowed. So that's not something to worry too much about in the filmmaking context or in the storytelling context. When it gets into, if it's just art and that's all the celebrity's images, the art, and there's not a lot of creativity from the creator who's doing the sort of downstream or subsequent use, that's when it gets to be more problematic. Okay, so that's the right of publicity in a nutshell. That's a very, very quick overview of the right of publicity. Now let's talk about copyright. So here's something to understand about copyright. Facts are not copyrightable, and ideas are not copyrightable. You can get paid to tell someone your idea. You can bring a breach of contract case for someone stealing your idea if there was implied or an actual contract, but you can't actually copyright your idea. And so that's something that's just very important. That doesn't even concern the doctrine of fair use. That's just something important. A key case when you're thinking about this question of making stories about real people, the law actually gives you latitude to use copyrighted material in doing that. So this case is a case called Dodger Productions versus Sofa Entertainment. So what happened here was the Jersey Boys was about the Four Seasons. It was a really good movie. It was a really, really popular musical on Broadway. I saw it at the Pantages Theater with my wife, and we spent a lot of money on the tickets. We had a great time. And then like 2 months later, the film came out streaming and we could have watched it for $10, but that's okay. We got to see the live performance. It was a lot of fun. So I'm just going to cut my losses. But what happened was in the live performance, right? So this is before the movie came out. In the live performance, they said, and then we hit the big time, and they show a clip of themselves being introduced on the Ed Sullivan Show. So the Ed Sullivan Show said, hey, what are you doing? That is not cool. You should have gotten permission to use our copyrighted content, the Ed Sullivan Show. And the court said, no, actually, that is what's called fair use. Fair use is a right to use copyrighted work without permission or payment if you're doing so for certain socially valuable uses like criticism or commentary or analysis of current events or news reporting, educational uses, research uses. So here the court said, no, this is permitted because the Jersey Boy musical creators were using this as a biographical anchor to help the audience understand what it meant to hit the big time. And the court allowed that to go forward. So when the Jersey Boys movie came out, guess what? The filmmaker said, we are going to use footage from Ed Sullivan Show and we are not going to get permission. And guess what happened? Nothing happened because Ed Sullivan Show knew that they would lose, and rightfully so, because again, they weren't showing the whole performance. They weren't selling copies of the performance or anything like that. But what they were doing is saying, hey, this is something relevant to something that actually happened in real life. And so this is a biographical anchor to help the viewer understand. The viewer can't really understand this Jersey Boys story without seeing at least a few or the Four Seasons story without seeing at least a few seconds of the Ed Sullivan Show. And that's all they showed, was a few seconds. So that's one example of where talking about real world material does give you special rights. Now, we talk about transformativeness and we talk about the limits in these other cases, and all of that comes out of the First Amendment. The First Amendment protects freedom of expression, and the Supreme Court has said many times that fair use is the safety valve that allows copyright to coexist with the First Amendment's guarantee of freedom of expression. So we use copyright. The reason we have fair use is because copyright cannot be a form of private censorship. It has to permit you to talk about culture, to talk about what's going on in the world, and to talk about it, you have to show it, particularly in the digital age and in the age of movies and TV that are ubiquitous, in the age of memes and people expressing themselves through popular culture. You just can't do that if you can't use any copyrighted material without permission. But that's also the grounds for the transformative doctrine in the right of publicity likeness rights context. That's the grounds for the newsworthiness exceptions as well. And so if you go back to the Haviland case and, if you read it, court is saying the First Amendment does not permit you to say, I need permission for you to tell the story about things that really happened and to take creative leaps and creative license in telling that story. Sometimes it's, let's go get a cup of coffee and talk about this, and you're imagining the conversation. And sometimes it might go further, right? And that's where you can get into trouble. And that leads us to defamation, right? So just using someone's likeness in a docudrama, biography, is not in and of itself. The First Amendment generally protects that as long as you're not just completely trading on the raw materials. So let's talk now about defamation. Okay, so defamation, the Queen of Versailles, the individual portrayed here, had signed a release. She brought a defamation claim and she lost because guess what? She had signed a release. But we have to know what defamation is, because here's the thing. There is no real allegation that what de Havilland did was defamatory. De Havilland didn't like it. She felt like it hurt her reputation. She felt like she should have been paid for that appearance. But that is not libel. That is not slander. Okay. And to prove libel or slander, you have to do certain things. Number one, you have to communicate that to someone other than the person defamed. So the law calls it publication, but it's actually you could just send an email to your best friend. That would be publication. It has to be a statement of fact, right? So this person is a scoundrel, not a statement of fact. This person is ugly, not a statement of fact. This person said the B word instead of dragon lady. That gets closer to statement of fact. But if you go to the next prong, it has to be about the plaintiff, but it also has to harm the reputation of the plaintiff. And that is not you have to show that certain things are flat out presumed to harm the reputation of the plaintiff, and you don't really have to prove any facts. One example of that would be someone has a communicable disease, someone committed crimes, and there's some older ones too about like sexual promiscuity and things like that, because defamation actually goes back several hundred years to English common law. But anyway, other than that, you have to show that. And then finally, if the plaintiff is a public figure, you have to prove actual malice. Now, actual malice doesn't actually mean I hate the person. It means you knew or had reason to know that what you were going to be printing was false, or putting in your film or whatever was false. And you knew it was false or recklessly disregarded its falsity. And if it's a private figure, so if you're just doing a little show about your next door neighbor and they're not a public figure and it's a nice quirky little film about your next door neighbor, then it's negligence, right, as to the falsity or not. But with a public figure, you have to know or have reason to know or recklessly disregard the possibility that what you're saying wasn't true. And it's interesting, the First Amendment does not prohibit lying. You can say the vaccine doesn't work, but if you say, Anthony Fauci is a bad guy and he doesn't know science, that would be opinion. If you say Anthony Fauci is a bad guy and he is falsifying data, and if you know or have reason to know that that's false, then it might be actionable. So those are some ways that plays out. So, when we're vetting a film, the right of publicity questions, the likeness rights, so to speak, are not very difficult. What is much more difficult is defamation. And there's a number of other torts, which for the lay people in the house are legally recognized wrongs, right? Defamation is a tort. Hitting someone is battery. hitting someone and making them flinch is assault, and so on and so forth. Those are torts. And so there are a number of other torts. Another one is trespass is a tort. Invasion of privacy or intrusion upon seclusion is a tort. So a good example there is maybe you are embedded with a fire department. This is an actual case from, I believe, Florida. You're embedded with the fire department as a journalist, and you follow the fire department into the house to help to watch them try to rescue someone, and you film what's going on in the house, and it's not a trespass, but that was held to be invasion of privacy, or in California it's called intrusion upon seclusion. And another one that we'll talk about in a second is publication of private facts. So if you publish something about somebody's finances or their sex life or something, or maybe their medical issues, and we'll talk about publication of private facts in a second. I want to get to this next slide about defamation, because again, this is something that, as lawyers, we look much more towards defamation than we do towards these other things. One, you've heard this probably, truth is always a defense. So the idea here is, hey, if Anthony Fauci actually did falsify data, even if that's very embarrassing to him, too bad. That's not defamation. We're done here, right? Then there are a number of privileges, right? So one is any government document. So if somebody says something and they say on the stand, oh yeah, Anthony Fauci testify. I don't know why I'm picking on Anthony Fauci here, by the way, Dr. Fauci, but let's just go with it. So if Anthony Fauci someone goes on the stand and says Anthony Fauci falsified data, that would not be defamatory, because you just be reporting on what was said in these government documents or what was said in court on the stand, and you can repeat that without defaming someone. But if you have a source that tells you that, and or have reckless disregard for the possibility that it would be false, then you can get into trouble. Fair comment is like, if you're commenting on movies or something like that. So criticism and commentary, very similar to fair use and copyright. And then fair reporting is like, okay, there's a major report from a nonprofit organization that accuses Chevron of dumping 20,000 gallons into LA Harbor. That would be of oil or whatever. That would be fair reporting. And so there's a privilege for that as well. Getting multiple sources. One thing that we do if we have something that's really controversial, and a lot of lawyers do this, they'll say, okay, well, how do you know that? Show us the source, and can you get more than one person to say that, right? And so then even if it's false, you have reason to believe that. Now, if you just get an anonymous call, hey, Anthony Fauci falsified data, and then you say, hey, let's run with it. Or, if someone who's a known liar says it, and they have an agenda for saying it, that might be problematic as well. Again, different standard for private versus public figures. So if it's a celebrity, if it is a government official, if it is a police officer, it's a public figure. And again, hyperbole and exaggeration are okay, right? So I can say Anthony Fauci is the literally worst person in the world. That would not be actionable. So these are some things to keep in mind. Now, in California, but not in New York, we have another tort, another legally recognized wrong called false light. And the classic example there is a coach is arrested for molestation, but the newspaper photo shows a bunch of other people. And there's this implication that the person did something really horrible. And so their reputation is damaged that way. And so that is an example of false light. That's the classic example. It's not actually used very often. People always throw it in when they're unhappy about being portrayed and they issue a complaint. But there is not a lot of case law on this, because it very rarely applies. Because if you speak about the person, now you're into defamation. So it's only when there's some implication, and again, a classic example is a photo that's wrongly captioned or something like that. Okay, so publication of private facts is another action that's recognized by California courts. Here, a classic example is this film, The Red Kimono, which is about a former prostitute that used her maiden name. And this is from 1931. Another example is officers sent really, really graphic accident pictures to people who are unrelated to an investigation. Publication of private facts doesn't come up that often, because you have a matter of legitimate public concern. If it's newsworthy, then it's going to be okay. And that sort of trumps any issue around publication of private facts. And so these are, and there's an objectionable to the reasonable person standard as well. So if it's like, Jack Lerner, all of his suits are plaid, like he's such a weirdo, all of his suits are plaid, that probably would not rise to a level of objectionable to the reasonable person, as opposed to, graphic photographs of an injury that somebody would have or something like that. And so courts draw, and this is a quote from the cases. And by the way, if you want a great summary of these things, there's a treatise, many of you who are lawyers know about this, called Witkin Summary of California Law, which is, just goes through all the elements. It's a really way to get a basic overview of these things. And so there's a case called Jackson versus Mayweather, where basically the court says, look, if there's no connection to newsworthiness, if it's just prying into private lives, a morbid and sensational prying into private lives for its own sake, that is the kind of thing that is going to be actionable. So you got to be careful about that as well. If it's something really sensitive, graphic content, or something, about somebody's finances, that's not newsworthy. Something about somebody's finances, if let's say you're doing a nice little slice of life piece about your neighbor, and you find out, wow, your neighbor lost, $500,000 at the casino last night, and they're going to go bankrupt. That's the kind of thing that, as a lawyer, I would say, let's do some research on publication of private facts and make sure that this is not going to get you into trouble, because that's not newsworthy. This is just a guy. This isn't the mayor. This isn't the comptroller of a huge company, who now we know can't be trusted with access to funds. This is just some guy or gal or whoever, right? And so that's where you get into trouble. What I want to do now is talk about the practical reasons why you might want to get a release and other factors. And I want to start with errors and omissions insurance, right? So when you talk about a film production, but also a lot of books as well, get errors and omissions insurance. So when you get E&O insurance, it's actually not called E&O insurance, really. It's called media liability insurance. And these are some of the companies that have offered it. I think some of their names have changed. They're always kind of reforming or getting acquired or whatever, but thank goodness it's actually a pretty competitive market, and these companies offer reasonable rates, and they do things like insure for fair use if you get a letter from a lawyer. And this is something we do in the law clinic a lot. People will come to us with all kinds of stuff that they haven't got permission for, but they actually have a right to use under the doctrine of fair use. If you do it, that's a whole nother presentation, but if you do it appropriately and smartly, then you can use sometimes a lot of material without permission or payment. And the First Amendment allows you to do it. And the statute and the doctrines allow you to do it. So media liability insurance. So it's essentially a policy, filmmakers get it sometimes before they go to festivals. Sometimes they have to get it as part of a distribution deal. So if you're going to screen something on HBO, they're going to say, go get E&O insurance, right? You have to get that. Sometimes before you go to a big festival like Sundance or Tribeca, you might want to get it. What's great about this insurance is it's not just, E&O means errors and omissions insurance. So like, let's say you lost your copy of a release. That's an error or an omission, right? Or banks have to get it and businesses get it as well when they're closing a deal and that kind of thing. But filmmakers also get it for that reason. So let's say I want to hire someone to write a score for my film. They deliver the score, I pay them, everything's fine. And then a year later, I get a letter from a lawyer saying, hey, Jane didn't write the score. Billy wrote the score, and Billy, he wants you to pay. That's when you file a claim with your insurance company. But media liability also protects against right of publicity claims, defamation claims, and so on. Again, I'm focusing a lot on film because I work more with filmmakers. So this is just one data point. Premiums cost, they're usually 3-year premium. They go to the inception of the project, which is great because you can go retroactively. And then they go for 3 years usually, and they're worldwide, which helps when you want to do something around the world and not just in the United States. Premiums cost between $1,500 and $5,000, and deductibles are high. They're usually $25,000 or maybe $10,000, right? So even if you're going to get E&O insurance, it's not like you can say, oh, well, I can be careless with how I'm talking about people, or I can be careless with fair use. No, you still have to be very scrupulous and have your ducks in a row. But what this insurance does is it essentially enables you to move forward, knowing, not just knowing that your liability is limited, but more importantly, all the gatekeepers that you're working with, the distributors, the streamers, the theatrical people, the sales agents, they all can rest easy that this is ready to go. And there's an underwriting process that helps it too. So E&O is important. I thought I would talk a little bit about this. I mean, it's basically insurance against not having all the paperwork in order. But what's great is, again, it covers copyright infringement, likeness rights, libel, all that stuff. Why get a release, right? So here are 3 examples where they got releases and then the subjects came after the filmmakers and lost. Queen of Versailles, Lily Tomlin was profiled, 20 or 30 years ago, and she came forward and she was actually on camera agreeing to being filmed. So she went away after that. And then in Borat, they got releases and a lot of people complained because they looked very bad, but the releases were pretty broad and they held up in court. And of course, Borat, they didn't just go out and do it Gonzo style, so to speak. They had lawyers all the way along drafting the releases and making sure they were doing it right. And they still push the envelope, let's be clear. But these are 3 examples. So why get a release? 2 reasons. The first one is it is great to lower your liability. The release says you have permission. The release says you're getting paid often, or other kinds of consideration, which we'll talk about. The release, best of all, it says, I waive and release you from any and all claims, right of publicity, defamation, libel, which is version defamation, copyright claims, trademark claims, and so on. And they spell out the rights. And if someone signs a release, usually, or a life story rights agreement, slightly different, but if they sign something like this, then they're on notice that they know what you're going to do with the work and that they're agreeing to it. And so it becomes extremely valuable to do. And so that's why you want to get a release and why many people do get a release. Now, compensating subjects and exploiting subjects is something that in the documentary film community, people are talking about a lot, right? And so even if you have a really unsophisticated subject of your film, whether it's a docudrama or an inspired by a true story, or whether it's a straight up documentary, you want to make sure that your subject, it's a matter of ethics, that your subject understands what they're getting into. They understand the value of what they're giving you in terms of the release that they're giving you. You want to establish trust with them. Now, we've gone before, you don't necessarily need to get a release as far as the law, but if you don't, 2 things can happen. Number one, the subject might be more prone to get upset. Now, of course, we see from these examples that sometimes the subject gets upset even if you get a release, but the release protects you. But another reason is because you need to get more letters from lawyers for the errors and omissions insurers in order to get coverage. So, the insurance application will say, do you have permission from everybody in the film that appears? And if you say no, maybe you'll say, no, there's some people, like I filmed a parade and there were a bunch of people in the parade, that, the insurer is not going to care about that. But if you say, well, no, I have 10 interviews and I profiled a bunch of people, like, at a backyard fighting club, if you don't have releases from them, then you're going to need to get a lawyer to look at the footage at your cut and say what, or, for the writers in the house, or at your story, and say who is being discussed, who is being portrayed, and we're going to go through all the claims. And so let me take you through what that looks like, right? So when someone comes to us, we ask all these questions, right? Okay, so when you were collecting your footage or doing your reporting, did you commit trespass? We need to know about that. Did you tape anyone without their permission? In California, it's illegal. It's actually a crime to tape somebody, to record anyone without their permission. And that's not just one, you need both people's permission. Unlike some other states, you only need one party's permission, but you need all parties' permission. So if 3 people are on the call, they all have to consent. And that's why when you're on Zoom and it says, hey, you're being recorded, do you consent? If not, you have to leave the thing. You're put on notice, right? Music, they're the 2 areas where people are most litigious by far: music and photography. So we look really closely at music and photography. Sometimes music can be fair use, right? If you say, oh my God, I listen to the song every morning, it kept me alive. Like, I don't know where I would be without this song. And the song went blah, blah, blah. We've written opinion letters for fair use of major songs from the 60s that sold millions of copies that would cost tens of thousands of dollars to license for the film, because that was pertinent to the exact historical moment, and the song and was either played at a moment in time where, you know, a protest was happening or something like that, or in another case, the song was about the event being portrayed. So we said that's going to be okay to use. But there are many cases where someone says, well, there's a song that's really pertinent, you know, it's all like, you know, this is a film about depression and this song is about depression, and can I use it in the credits? The answer is no, that's not fair use. That's never going to be fair use. Now, maybe you can say, well, we went to a concert, and this is more in the documentary space. Maybe we went to a concert and you can show a few seconds of the concert. You probably cannot show the whole performance, but so on. So music we look at. Defamation, libel, slander. We've talked about false light, publication of private facts. And there again, you know, where it comes up most is whether it's extremely graphic content. And if it's about something that's really not newsworthy, that's just a slice of life type story, that's where you might want to look at it. Now, one thing I haven't talked about when it comes to copyright is if you, and this has come up in the clinic with our clients, every member of the crew and the production crew should sign a work made for hire agreement that says the filmmaker is the one who owns the film company, or the filmmaker is the one who owns the right and owns all of your intellectual contributions, right? So if an editor is in there editing away, or the camera person is in there filming, you want to have work made for hire agreements for all of your crew. And then you want assignments or work made for hire agreements for your person who writes the score, your composer, and all that stuff. Trademark. Generally, I'm not going to talk too much about trademark as we're talking more about real people, but with trademark, you want to think about, the main thing to think about, you know, when you see things that are blurred out on TV, 9 times out of 10, that is because the producers were just scared, or they're doing product placements and they don't want to give anyone else free airtime. You don't have to blur out reality to portray reality, right? So if I'm in the dorm and I'm filming a student, and the student has, you know, a Gucci bag on her shoulder or on her desk, that I don't have to, you know, yeah, the Gucci trademark is there, but that's fine. There's nothing that would be protected by the First Amendment exception to trademark. You can have comparative examples, and, you know, if you want to do a story about different types of bags, you know, Gucci versus Fendi would be fine. And that's also true. We call that incidental use in copyright, in copyright circles. So let's say there's a picture of Beyonce on the wall in the dorm where I'm interviewing someone. I don't have to blur out Beyonce, but we look for those things, right? That, you know, if somebody drinks a can of Coke and drops dead, that can actually be a trademark issue, because now you're tarnishing or diluting the Coca-Cola mark. But if somebody just has a can of Coke and they're drinking it the way that someone would, and you want to say, yeah, you know, this character liked Coca-Cola, or, you know, this character liked Diet Coke or whatever, that would be okay. We've talked about right of publicity. So when we're looking at a defamation, we like to say, okay, who's a private figure versus who's a public figure? What was said? You know, are you quoting from people on the record or off the record? What kind of written statements are you looking at, and so on? And we actually, and this brings to, so we, you know, and people in the field, if it's a script, we ask the filmmaker to go through the script, and often lawyers for documentary filmmakers will go through all of the narration, whether it's a script or an interview, and literally pick out every factual assertion and ask, okay, how do we know this is true? Do you have a newspaper article? Is this possibly defamatory? And evaluate every single statement. And if you think that that's tedious work, it is tedious. It's not very glamorous, but it's really cool when you see the work on TV. But it's still, you know, it is very exacting, very tedious work. And when we're doing fair use counseling, same thing. We're looking at every single clip down to the second and saying, you know, is this justifiable? So it's a very exacting process. This list comes from Jerry Nagin with Rosenfeld, Meyer, and Sussman, entertainment lawyers in Beverly Hills. He's terrific, and he and I co-presented some time ago. And so he asked for all of these things from the writers of the productions that he advises, right? We want to know, we want to list all of the character, on whom are they based? If a character is portrayed in an unfavorable light, tell us why why that's justified, what the choice is there. Because what we want to do is say, can this stand up to a defamation charge, right? Is this a problem? What kinds of permissions have you gotten? And then sometimes folks will ask their clients to actually annotate the script. This portrayal, is it factual? Is it inferred from fact? Or is it totally fictional? And of course, then you also want to think about credit. Who else worked on the screenplay? You don't want an ownership dispute later on down the road. Similarly, you might ask the client to list all of identifiable people. This is more for docudramas and biopics and inspired by. This isn't really done as much in documentary filmmaking, but having the client actually go through and annotate the script is one way to do it. Now I want to talk about, so let's say you want to go ahead and get permission. And again, there's lots of reasons to do it. You want the subject's cooperation. You want the subject to not be able to sue you later, obviously. Sometimes you can get exclusivity, right? And that's one of the key reasons why you want to get a live story rights agreement, because then you can actually, maybe you have to compensate the subject, or maybe you can make the subject, an associate producer. There's other ways. If you don't want to directly pay them, you can pay them like a location fee for the interview or something like that, as opposed to bringing them on as a co-producer or something. But anyway, for whatever consideration you agree on, getting exclusivity is one of the key reasons why people want to get life story agreements. So those are some of the reasons. Obviously, the insurance company likes it better when there is an agreement. And, you also want, most of the time, you want the subject to help promote the film, right? Come to the screenings, come to the film festivals. And that's a big deal. And if instead you're kind of out there by yourself, or the subject is, making comments in the press, or worse yet, sending you a cease and desist letter, that can really mess up the film, particularly if it messes up your insurance. And so I often advise my clients to get insurance at the outset of the production process. Don't wait until you're later in the process. So these are some of the key provisions you want in a life story rights agreement. Okay, so definition of life story. So what does that mean? You want that to be fairly broad, right? So, things like, it's going to include your likeness, your voice, your biography, your actual, your life story. You're allowed to impersonate or simulate the subject in any way, make use of incidents in the owner's life. And so, but you want to define broadly what it is. Most of the time, people aren't going to agree to a life story agreement just forever, particularly if there's exclusivity involved. And so often there will be an option, right? And so you'll say, okay, give me 3 years to make this film, or maybe it'll be 3 years or 1 year after it premieres at a major film festival, or 2 years after it premieres at a major film festival, something like that. But usually there's a time limited option with an agreement, particularly if there's exclusivity. Consideration. So in the law, consideration means something that you get that's bargained for, that the other side gets, right? So, or that both sides get. So often that's money changes hands, or I give you my time, you give me money. That's the consideration. Each side gets something, but it doesn't have to be money. It might be credit. It might be special thanks to my subject. It might be special thanks and we'll fly you to the premiere. It might be special thanks and whatever. So that might be something you want in there. You want to spell out what rights are being given, right? So the right to use the likeness and the life story, the right to show it or distribute it, to publicize and advertise it. You want to make sure you can use somebody's image in a movie poster and on t-shirts or related to the film or something like that. And then merchandising is tricky. It's usually more than just one clause that you put into a life story rights agreement, but sometimes you can put in a paragraph size clause. Another very, 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 very extremely important provision in a life story rights agreement is the release, right? So you want to include in your agreement, I release you, I waive and release and forego, blah, 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 any and all claims. And then you spell them out. defamation, right of publicity, copyright, trademark, and so on, for now and forever, and so on and so forth. And this is really important because, I mean, this is really even more important than grant of rights, because one of the main reasons you get this is so the person can't be later decide that they're unhappy with your work and come back and sue you. So that's that. I want to tell you one quick story about this: distribute, exhibit, manufacture, or otherwise exploit. And I was actually just reading about this morning. So Miramax Films has brought a lawsuit against Quentin Tarantino because Quentin Tarantino said, I'm going to release an NFT, a non-fungible token, to various things. And Miramax said, hey, you gave us all rights in all media now or forever, invent any media to be invented in the future. And whenever lawyers see this and lay people see this, they're like, that's so funny, like throughout the universe and whatever is created. And here's an example. Nobody had any idea in 1993 when he signed that agreement for Pulp Fiction that NFTs would exist. But here they are, 28 years later. A couple of other things in a life story rights agreement, and we're pretty much done. You might want to have language in there about a pseudonym. You might want to have, this is also really key with a lot of life story rights agreements, something about like, you're going to cooperate with us. If we want to come back and ask you questions, you'll do your best efforts. Often one reason you want to get a life story rights agreement is because there's a lot of non-public letters, photos, and things like that you can get from the subject that you can't get. And another key thing that you always need, unless it's like a one-page interview release, but if it's giving any rights like copyright rights or materials rights, you want representations and warranties that you have the right to do that. And then an indemnification is like, and if I get sued, you'll pay my legal bills. And so this is something that's just standard in many IP contracts. It's not usually in little releases that you give before like an interview. Those are mostly release of claims. You might say, oh, there's nothing prevents me from getting material that's in the public domain or that's publicly known. And, this is the entire understanding. One thing I don't have in here that I probably should is a clause that says, I have final cut. Or you give notes, but that's it. Or you give notes on the final cut, or you give notes, one month before screening, something like that. But you want to spell out what input, if any, the subject is going to have. And I will almost never let my client give say over the final cut to the subject or to anybody else. That is a big no-no in my view. Finally, there are a number of really great resources. There is a Donaldson and Califf book called Clearance and Copyright, very popular, very affordable. It's awesome. And then there are 3 treatises you can get on Westlaw or Nexus for the lawyers, which have nice life story rights agreements with comments and things like that. So now I am going to start taking questions. Here I am back in my office here in Irvine. Let's see what we have.
Can you explain the copyright that photographers have in photos they take? And what rights do models have who are being photographed in those pictures?
Whoever takes a picture owns that photograph, okay? So you see pictures now of models and celebrities putting pictures of themselves on Instagram and then getting sued by the photographer that took a picture of that celebrity, of that person. And if it sounds messed up, that's because copyright is so long, so strong, and so broad, it just causes problems for a lot of people, and it really runs counter to how people conduct their lives. But that's the answer. And that's why if you've got a production where you're hiring someone, you want ironclad work for hire agreements or assignments that give you exclusive rights to anything that any photographs that camera person or that individual takes. Models usually sign a release that says you can do whatever you want with the pictures. And there was actually what was the woman who was in the Emily Ratajkowski had some of her photos, which are very risque, published. And she wrote about how she went over to the photographer's home and got drunk and really didn't realize what was going on. Some of those releases that the models sign say things like, well, this can't be used for, pornography and things like that. But generally, they have very little rights after the photos are taken.
If an audience or fans are filmed at post-show events where faces are recognizable, is a release necessary?
Generally not, unless people don't know they're being filmed, and then that could be more difficult. But if you're just showing a big audience, not necessarily. If people know that they're being filmed, And so, that being said, you want to make sure they know if you can. Sometimes that's something on the ticket, something that's signs or announcements at the venue. And sometimes that's actually people signing releases before they can come in. And we've all probably seen that, especially around LA, like notices, hey, filming is going to take place here. And if you walk down this block, you might be in the shot. So guess what?
I interviewed a person at a donated space. There were art photos behind the interviewee because we were at the donor's apartment. Do I need the photographer's permission?
That is going to be protected by fair use unless you stage the set. If you stage the set, then it becomes an issue. So like I said, if I am filming, I'm doing a movie about life in the dorms here at UC Irvine, and I'm going in and interviewing people, and there's a Beyonce poster on the wall, I don't have to blur out reality to show reality.
Do you need to get permission if you create a fictional piece based loosely on a person's actual life or an event from their life?
Not necessarily, really, no, but there are lots of reasons why you might want to get one. And if you're going to be getting over towards defamation or something where you're getting really into graphic elements of that person's private life, then that's more of a difficult. But again, there are a lot of functional reasons why you might want to do that.
What releases do I need for a deceased person from his estate?
Similar release. So it depends. I mean, you don't necessarily need a release from a deceased person, but if you're worried about them coming back to you, or the distributor or the insurance company asks for one, then you can get one. But we have our filmmakers come in with absolutely countless photos of real individuals particularly in the archival setting, that they don't have releases from them, and we use them. I literally could not count how many I've looked at even in the last week that involve that, so particularly prominent people, but it might be just some academic. We just signed off, for example, on a film where the filmmaker is quoting from some academics, and he shows the pictures of the academics. And not only is that fair use or permitted use because they're the headshot publicity shots, but the First Amendment allows you to do that. So you don't really need that. That's not a concern most people be worried about. It would be different, again, if you're drilling down, getting really into that person, that's when you start wanting to be either have a lawyer look at it more carefully or get a release.
Free image and video sites such as Pixabay and Unsplash state that we can use their materials for free without attribution. Does that sound okay?
Yes, it sounds okay. Unfortunately, it's not necessarily okay. What we've seen is that some of the stuff that's on Pixabay and Unsplash, which say, yeah, you can use this is uploaded by the community, they're user-generated content sites. And if someone puts infringing content up there and you don't know where it comes from, you could get into trouble. So we're very careful. We used to say, oh, it's from Pixabay, we're good to go. Now we actually take a much closer look at Pixabay and Unsplash for these reasons. And we say, okay, like maybe sometime on those websites, there are some users on those websites that are kind of like power users. And you can kind of tell it's their photography and they have given it to the world, and that makes them a great person. Flickr also has those kinds of licenses too. And generally you can kind of suss out when it's some cretin that's just uploading somebody else's content and when it's somebody's own content. And so that's kind of how we approach that. We kind of sniff around and see, is this legit or does it look like a professional photograph that somebody uploaded? And sometimes we'll do a Google reverse image search as well to investigate that. But unfortunately, Pixabay and Unsplash, you can't really trust them. And another reason why you can't trust them is because in recent years, and you can actually see a study that we did of this in the clinic on our website. In recent years, photographers have gone crazy with litigation against all kinds of people, especially news gathering organizations, media organizations. They're bringing massive numbers in the thousands of lawsuits based on people using their images on the web. So we have to be really careful with photographs. And I'll end it at that.
Thank you so much for answering all our questions and, being so thorough. Yeah, thank you so much for joining us today.
You're welcome.